everyone. The West Bengal National University of Juridical Sciences, Kolkata would like to welcome all of you to the second Shri M.K. Nambyar lecture From Bhopal to Saha, the promise and problems of effective legal remedy. The M.K. Nambyar lecture series was instituted by the famous Supreme Court Senior Counsel K.K. Venugopal in the memory of his late father, Barrister M.K. Nambyar. M.K. Nambyar has left an indelible mark upon Indian constitutional law. His legacy and commitment to free speech still lives on in lecture series that was instituted in his name. I would take this opportunity to welcome all the dignitaries present on dais and in the audience, and I would now request student representatives of the college to felicitate them with tokens of our gratitude for being here today. I would like to welcome first Professor Marc S. Galanter. He is the Distinguished Professor of Law and South Asian Studies at the University of Wisconsin, Madison, and LSE Centennial Professor at the London School of Economics. Can we have a huge round of applause for him? We have the distinguished privilege of having Ms. Chandrama Bhattacharya, the Honorable Minister of Law, Judicial Affairs and Health, preside as the guest of honor for today's lecture series. We welcome you, ma'am. And last but not least, we have Mr. Krishnan Venugopal with us, the grandson of Mr. M.K. Nambyar, a senior advocate at the Supreme Court who has made his mark in commercial arbitration, trade law, and constitutional law in India. Can we please welcome him with a huge round of applause? I would also take this opportunity to welcome other dignitaries present with us in the gathering today. We have with us Honorable Justice Mr. Joymalyo Bagchi. We have Sir Nishit Adhikari and Dr. Satyajit Dasgupta, Professor Vibhuti, Professor Gangotri Chakraborty, Professor Sujoy Bosu, and we have Sylvia ma'am with us. Thank you so much for being here. We have Sir Sholindu Basu, and we have Dr. Satyajit Dasgupta and his entire team with us. Can we have a huge round of applause for everyone? And my apologies if I have missed out on anybody's name, but we welcome you and we are glad that you're here with us for the lecture series today. With that, I would like to request our Vice Chancellor, Dr. P. Ishwara Bhatt, to please come and address the gathering.
Honorable Justice Altamas Kabir, President of this session, Professor Marc Galanter, Speaker of this second M.K. Nambyar lecture, Mr. Krishnan Venugopal, Madam Chandrama Bhattacharya, all the invitees, ladies and gentlemen. It gives me great pleasure to welcome on behalf of WBNUJS the distinguished scholar, Professor Marc Galanter, who will be delivering a second M.K. Nambyar lecture. The lecture is in the name of Mr. M.K. Nambyar. Endowment was constituted by his illustrious son, Mr. K.K. Venugopal, 2 years ago. And this is the second lecture that we are organizing. M.K. Nambyar is known for his distinguished contribution to the field of public law. He hailed from Chenmanad village of North Kerala. He did his LLB degree from Madras Law College. Earlier, he was in Mangalore. Then he went to England in 1931, and he did his bar at law in 1933. His contribution to the field of public law is quite significant, especially the famous argument that he had put forward in A.K. Gopalan case was the trendsetter, and it became the main law of today. Although at that time his argument relating to reasonableness was accepted, the major argument relating to interrelationship of fundamental rights was not well accepted. But subsequently we find that in Maneka Gandhi case and other cases it was accepted. Then his famous cases are those relating to constitutional amendment. He appeared in cases like Express Newspaper Company case, Bennett Coleman Company case, B.N. Nagarajan case, Western Ramnad electric distribution case, Deepchand case, then other cases also, R.C. Cooper and other Madhavraj Scindia case. In all those cases he put forward his brilliant arguments relating to the central place for liberty, equality, so that the fundamental rights jurisprudence will be established on the basis of those primary principles. And after Maneka Gandhi case, it has become a mainstream law. He had that foresight, he had that perception, and contribution that he had made to the field of public law is very, very significant. And it is befitting that his illustrious son, Mr. K.K. Venugopal, established this endowment and funded even the lecture by special grant also. On behalf of NUJS, let me congratulate, let me thank Mr. Venugopal for providing these facilities. Then let me welcome Professor Marc Galanter, who is a very eminent professor of law, South Asian Studies, University of Wisconsin Law School. He had a long association with the Indian legal system. Being a Fulbright scholar in the 1950s, he had developed that intimacy, and his contribution in the form of a famous article, Why the Haves Come Out Ahead, Speculation on the Limits of Legal Change. This article is the most cited articles in legal literature. Perhaps his insight to the Indian legal system, the differentiation between haves and have-nots, had enabled him to develop that theme that it is the haves which dominate and who influence the course of a legal system, and it is essential that there ought to be adequate method through which parity in the parties to litigation ought to be established. Ultimately, promotion of ADR and promotion of public interest litigation and other developments took place. Of course, in India, the repeaters syndrome is not something that much dominant, whereas repeaters syndrome in the form of MC Mehta cases and other cases point out that there is a much social dimension to that repeater system. Who are the litigants, they are not always a rich class. Many of the times it is the poorer section of the society who also get represented through various organizations. Public interest litigation has actually come to the help of the poorer section of the society. The idea that he has projected relating to the legal system is quite significant, and his subsequent major contribution is in the form of a book, a voluminous book on competing equalities, law and the backward classes in India. He points out how between a substantial equality and formal equality there is a competition, and that is resolved by introduction of a compensatory discrimination policy. And here the judiciary plays the role of balancing wheel, whereas it is the political process which introduces some policies or which provides some leading role or which determines the contours of the major policy of the legal system. Of course, he arrives at a conclusion that the judiciary, while controls such policies by the counter-majoritarian approach, it is ultimately the society which determines the major thrust of the policy relating to compensatory discrimination. That's whether it is by supporting or challenging or say identifying itself with the compensatory policy. It is the society which formulates the major approach relating to the way in which the problem relating to backward class of citizens is to be addressed. Perhaps that's his biggest contribution, and in his works we come across that approach relating to law-society interaction, and his famous work Law and Society in Modern India is epoch-making, and perhaps more than to the American legal system, it is to the Indian and Asian legal system that he has made that kind of important contribution. It is fortunate that for a second MK Nambyar lecture, he had agreed, and he is here all the way from Wisconsin. He has moved entirely for this MK Nambyar lecture, and on behalf of NUJS, let me heartily welcome Professor Marc Galanter. We are actually looking for his lecture from Bhopal to Saha, Promise and Problems of Effective Legal Remedy. Once again, some innovative ideas or impartial and objective assessment of the whole of the trajectory of the case law from Bhopal to Kunal Saha. He will be putting forward his thoughts. We are eagerly looking forward to that. Let me welcome Honorable Justice Altamas Kabir, former Chief Justice of India. He was a practicing senior advocate in Kolkata High Court, elevated to the position of a High Court judge in to Kolkata High Court. Subsequently, he served as the Chief Justice of Jharkhand and other High Courts, and he was elevated to Supreme Court, and ultimately he became a Chief Justice of India in 2013, and as a Chief Justice of India and as a Judge of the Supreme Court, he rendered a number of brilliant judgments relating to child rights, the institution of work, and various other important issues on educational rights and other rights. He made a very big contribution, and he has closely associated with the university as an honorary professor. He was teaching for our students for law and the child, and this semester he has taken up the elective subject of minority rights, and students are eagerly attending his lecture, and it is one of the most successful lecture that I should say. On behalf of NUJS, let me welcome Honorable Justice Altamas Kabir for agreeing for standing presentation. Let me welcome Honorable Minister for Law and Health, Madam Chandra Bhattacharya. She is a member of our Executive Council, General Council, and she has taken a keen and sincere interest in the development of the university. She is responsible for some of the important decisions that the government has taken, especially about the grant of funds or about release of this grant for instituting a chair in the name of Ashutosh Mukherjee. Sir Ashutosh Mukherjee chair on a Bengal tradition, law and social transformation is a mark of the government's recognition of the need to study the Bengal tradition relating to law and social transformation. There is quite a significant area for which the government has agreed, and the central role played by Chandra Bhattacharya ji is something quite significant. And even about the transfer of land which we are seeking, I am expecting that there will be some prominent decision, and we are badly in need of some land space as well as building, so that our students can be accommodated in good residential units. Hostel can be established, and guest house can be established, or various other facilities could be there. Madam, I am welcoming you on behalf of the university. I am expecting on behalf of the university that there will be a lot of good things from your side, and we are thankful for your gracious presence. I am welcoming on behalf of NUJS Mr. Krishnan Venugopal. He is representing the Venugopal Trust, and of course he has come all the way from Delhi to represent the trust, and as a product of Delhi University, and also had a good amount of expertise in the field of corporate law and other spheres. He is doing very well in the field of public law and assisting his father. And of course, on behalf of NUJS, let me heartily welcome Mr. Krishnan Venugopal, and let us wish all the best. Thank you very much for your presence. Yes, today we have Emeritus Honorable Justice Jaimalya Bagchi. Yes, his association with the university is continuous, and of course he has been delivering lectures on some of the issues like contempt of court, and it's also one of the important contributions to the method of, to the learning process here. On behalf of NUJS, I am welcoming you, sir. I am welcoming Mr. Nishita Adhikari, welcoming Mr. Professor Sujay Basu, Professor Vibhote, Professor Gangotri Chakravarti, and various other dignitaries. Professor I.G. Ahmad and various other scholars have come. I am welcoming all the students, faculty members, and the invitees. With this, let me conclude my welcome speech. Thank you very much.
Thank you. As the guest of honor, Ms. Chandrima Bhattacharya, Minister of Law, Judicial Affairs and Health, to kindly come and address the gathering and release the Journal of Indian Law and Society. It is a biannual peer-reviewed interdisciplinary journal brought out by the students of the university, and we are indeed glad that we could have ma'am release the latest issue. Can we have a huge round of applause, please? Now request ma'am to kindly come and address the gathering. Thank you.
Honorable Justice Altamas Kabir, former Chief Justice of India, respected Professor Galanter, respected Vice Chancellor Professor Bhatt, Justice Joymallo Bagchi, a sitting judge of the Honorable Kolkata High Court, distinguished guests, ladies and gentlemen, and on the dais is also present Mr. Krishnan Venugopal. It is a pleasure to address this august gathering today as the guest of honor on the occasion of the second M.K. Nambyar Memorial Lecture at NUJS. As the Law Minister of West Bengal, I am proud to state that NUJS today is one of the premier legal institutions in India, established on the basis of the famed National Law School model in 1999, with the Honorable Chief Justice as Chancellor and the legendary Professor Madhava Menon as the first Vice Chancellor. NUJS has grown up leaps and bounds in recent years. I am convinced that the students and faculty of the university will continue to bring further laurels under the leadership of Professor Bhatt. The West Bengal government has been committed in assisting institutions by enabling upgradation of infrastructural facilities, by providing financial assistance to international mooters in special cases, and by establishing the Sir Justice Ashutosh Mukherjee Chair on Bengal Tradition, Law and Social Transformation. The government has great respect for the reformative legal tradition of Bengal and hopes to have good intellectual contributions from the chair. I appeal to all the students and faculty to make use of the opportunities and facilities available in the university and strive towards excellence in personal, professional and collective life. Today's lecture will memorialize Sri Nambyar. He was one of the finest constitutional lawyers the country has ever produced. His arguments in a range of landmark cases from A.K. Gopalan to Kolkata were visionary and now form a core part of judicial reasoning on democracy and human rights. The fact that his arguments were vindicated in later cases by the Supreme Court is the most fitting testament that his thoughts were well ahead of his time. His commitment to civil liberties remains an inspiration to all of us today. His son, eminent senior advocate K.K. Venugopal, has been generous in instituting this lecture, and his grandson is also present on the dais. I take this opportunity to pay my tribute to the constitutional expert who has laid down the path on which we are today walking. This is an excellent opportunity for the students and the faculty to interact with eminent scholars in the form of endowment lectures. It is indeed fitting that we have Professor Marc Galanter, a prominent expert on Indian law, to be delivering the lecture memorializing Sri Nambyar. Professor Galanter is a professor of law, Emeritus at the University of Wisconsin, Madison Law School. Due to his focus on empirical legal research, he is a leading figure in the law and society movement. He was editor of the Law and Society Review as well as the president of the Law and Society Association. He is well known for his article, Why the Haves Come Out Ahead, Speculations on the Limits of Legal Change, published in the Law and Society Review, which is one of the most cited legal articles of all time. His work encompasses dispute resolution, legal profession, legal systems, and access to justice, amongst others. We are thankful to you, sir, for being present here today. He has all along been associated with Indian institutions, having been a Fulbright scholar at the University of Delhi in 1957, a faculty fellow at the American Institute of Indian Studies, as well as a consultant on legal services to the Ford Foundation in India. His work on protective or compensatory discrimination in India, which includes his magnum opus, a book entitled Competing Equalities, Law and the Backward Classes in India, is very well known. Professor Galanter has also captured the complex Indian legal system in another popular book of his, Law and Society in Modern India. He has been an advisor to the Government of India on the Bhopal disaster and has assisted the Supreme Court in other cases too. I understand that this lecture today is entitled From Bhopal to Saha, the Promise and Problems of Effective Legal Remedy. For the Indian courts, developing an effective remedy for cases of large-scale injury has always been a conundrum. Bhopal gas disaster, which will see its 30th anniversary later this year, has a history of complex litigation which has been much critiqued upon. To this day, the case is being fought in courts in India and abroad, and several victims have remained without any compensation. The case saw large-scale litigation in various district courts, all pending, following which the government represented all the victims and the Supreme Court transferred all pending cases to itself. In the Upahar fire tragedy case, a number of moviegoers were charged to death in a cinema theatre fire tragedy. Dependents of the victim won a landmark civil compensation case, but it was subsequently diluted by the Indian Supreme Court. Today, the Supreme Court has awarded one of the highest compensation in a medical negligence case in India, the Saha's case. The repercussions and effects of the decision are yet to be seen. The common issue in all these cases has been the absence of a coherent system to provide legal remedies. I am confident that Professor Galanter, an expert in this field, will provide solutions which will go a long way in addressing these concerns. I hope that this excellent tradition continues for many years in NUJS, and we try to educate ourselves through these sorts of lectures in future too. Thank you all.
Thank you very much, ma'am, for those kind words and for giving us an insight into the theme for today's lecture. I would now request Mr. Krishnan Venugopal to kindly come and address the audience. Can we have a round of applause, please?
This is Chandrama Bhattacharjee, our guest of honor today. Professor Marc Galanter, Justice Altamash Kabir, Professor Ishwar Bhatt, Vice Chancellor, Honorable Mr. Justice Joymal Bagchi of the Kolkata High Court, professors and faculty of NUJS, as well as other institutions, academic institutions. Ladies and gentlemen, it's a great pleasure for me to be here today to welcome all of you to the second M.K. Nambyar Memorial Lecture. I would like to thank Professor Galanter for agreeing to deliver this lecture, and I really can't summarize his contributions to legal academia, either in the United States or in India. I took a look at his curriculum vitae and found it to be 19 pages long. He is an enormously accomplished man and has done a great deal of work at the intersection of law and sociology, not merely in the context of Indian society, but also in the context of our legal profession. I would also like to thank Mrs. Chandrama Bhattacharjee for agreeing to be the guest of honor today, and Justice Altamash Kabir, the former Chief Justice of India, for agreeing to deliver the concluding remarks. I would like to also say a few words about the late M.K. Nambyar, my grandfather. this case is an example of upward mobility in the legal profession more than 7 or 8 decades ago. He came from a landed family in the north of Kerala, from North Malabar, and had absolutely no godfathers in the legal profession. If you think back to those days, the legal profession in those days was dominated by a legal aristocracy, most of whom had been educated in England. In his case, however, he started out in Madras, in the Presidency College, did his degree from the Madras Law College, and started practice before he went to do the bar in England. He was extremely hardworking and did not really have financial support from his family in those days. The main reason being that he was the son of the second male member in a family that was based on Marumakatayam, which means that the lineage went down through the women and not through the men. The oldest brother of the lady would always be the head of the family, and it was he who controlled the money. So it was quite difficult for him in those days to make his way up in the legal profession. He started out in the district court in Mangalore, where he rose to be the public prosecutor, and then moved to Madras only after independence. There was a great communist called V.G. Rao who heard him arguing a criminal case and weaving in constitutional concepts to argue the case. He then asked my grandfather to represent the great communist A.K. Gopalan in a preventive detention case from the state of Kerala. He argued that case, I am told, before the Supreme Court for about 50 days. Or it went on for 50 days, and many of the arguments were reported on the front pages of the newspapers in those days. It is also said that because he was so unknown, some legal luminaries of the day, members of our Constituent Assembly like Alladi Krishnaswamy Iyer, requested V.G. Rao that they should be allowed to lead in the Supreme Court. But he stuck to his guns and said that M.K. Nambyar would argue the case first. At the end of that case, A.K. Gopalan is reported to have said that M.K. Nambyar made me famous and I made M.K. Nambyar famous. And after that, there was no looking back. Almost 2 decades later, he argued the Golaknath case, where the Indian Supreme Court for the first time laid fetters on the power of amendment of the Indian Constitution in 1967 by saying that Parliament could not seek to amend the fundamental rights, and that all amendments were subject to Article 13 of the Constitution. It was in that case that M.K. Nambyar argued the concept of a basic structure of the Constitution which could not be amended. At that time, however, India had a brilliant Chief Justice, Subbarao, who refused to accept the conventions of the day. And it was he who first laid the foundation for Keshavananda Bharati, which came in 1973, where the Supreme Court, by a majority of 7-6 on a bench of 13 judges, held that there was a structure, a basic structure to the Constitution, and that Parliament and the legislatures of the states could not amend that basic structure, which remains amorphous, I must say, to this day. Nobody really knows exactly what is part of that basic structure. All of you who are here are the students of NUJS are a self-selected group of people, the cream, if I may say so, of Indian students who did not wish to go into who did not wish to go into engineering or medicine, the conventional fields for middle-class folk. The fact remains that you are the elite, studying in an elite institution, and upward mobility in our profession is almost assured to you. MK Nambyar in many ways represents the same ideals that all of you aspire to. I would only urge that all of you also consider a career in litigation rather than solely in corporate law, as he did. Thank you very much.
Thank you, sir, for sharing with us the experiences in life of Sri M.K. Nambyar, and it was indeed a pleasure to have heard a bit of our rich history of development of constitutional law and the role played by Sri M.K. Nambyar in the same. And now I would request Professor Marc Galanter to kindly come on the dais and deliver the lecture for today. Can we have a huge round of applause for Professor Marc?
Distinguished guests, ladies and gentlemen, I want to first express my appreciation to Vice Chancellor Bhatt and his colleagues for inviting me to deliver the second M.K. Nambyar lecture, and to the donor, Mr. K.K. Venugopal, whose generosity has made this event possible. I didn't have the privilege of knowing Sri Nambyar, but the accounts of his erudition, his vision, and his dedication make understandable his immense contribution to helping the courts realize their potential as India's innovative troubleshooters, as well as her steadying gyroscope. He did much to direct the constitutional structure within which India's everyday legality can flourish. And I hope you'll find it fitting that I use this occasion to focus on everyday legality, to examine the prospects of using legal institutions to make them more responsive and effective in protecting the lives and well-being of ordinary citizens. Now, obviously, this is a goal with many dimensions, but I want to take this occasion, the 30th anniversary of the Bhopal disaster, to focus on an aspect that gets little attention: the protection of citizens from injury due to negligence and indifference. As a much indulged guest, let me begin by expressing my sincere gratitude for the gracious hospitality of WBNUJS. It's a great pleasure to be your guest. But I didn't come all this way just to say nice things and go home. I've been coming to India and thinking and writing about India's legal system for a long time. More than half a century, it turns out, although that seems hardly possible. Now, this doesn't give me insight superior to those of you who are immersed in it and committed to it in a way I can never be. But my marginality does give me a different outsider perspective, one that might usefully supplement or even challenge the insights of you insiders. So for what it's worth, I'm going to take this opportunity to tell you how things look from my perspective. If my account isn't always flattering, well, I wouldn't be here if I didn't admire and respect so much of what India has accomplished in these 60-some years of independence. Really a short time in the life of nations, just a moment in the arc of a great civilization. But obviously there's much more to be done. Now, I could be mistaken, but I'm a irrepressible optimist. I can't suppress my conviction that there are prospects for a better future, and that those gathered in this room represent in significant ways the capacity to realize those prospects. And it's in that spirit that I address you today, and I hope my remarks will be received with that wonderful receptiveness it has been my good fortune to find here. A receptiveness that need not exclude critical feedback from your side, but basically I want to use this opportunity to set in motion a conversation that I think is long overdue. A conversation about what happens when people get hurt. By accidents, by negligence, by indifference. How can legal institutions better help to comfort the victims and make such occurrences less frequent? This is, I submit, a conversation about the Constitution, not just in the technical sense of the obligations of government under Article 21, but in the broader sense of the fellow feeling, mutual recognition, and shared destiny that tie the citizens of India to one another. And in talking about the law of torts, we're not only talking about a device for compensating the injured, we're talking about a site for examining, elaborating, and dramatizing the responsibilities of human fellowship that constitute the sinew of a democratic society. Now, I'd like to do this by talking about 3 moments in the unfolding legal response to injury in India. Next Tuesday night, as you probably know, will be 30 years since the terrible gas leak at the Union Carbide plant in Bhopal, which ranks as the world's greatest industrial disaster. Now, Bhopal posed a challenge to the Indian legal system, which most observers agree did not acquit itself very well. Nor, I should add, did the American. Bhopal was the biggest and worst of many injurious events that take place in India, but there were many mini Bhopals, building collapses, mass poisonings, fires in hospitals and schools. These things occur with dismaying frequency. To respond to disaster in a way that both assuages the harm and reduces the risk of similar events in the future is a goal that grows more challenging as changing technology both increases the scale of potential harm, but also provides tools for prevention and remedy. Now, since many, or perhaps as I look around, most of you are not in a position to recall those events, let me briefly summarize. In 1968, the Union Carbide Corporation, an American multinational with subsidiaries throughout the world, built a chemical plant in Bhopal through its Indian subsidiary UCIL. UCIL had long made ever-ready batteries and other products at 14 plants in India. The UCIL plant in Bhopal was granted a license to manufacture pesticides in 1974, and starting in 1979, the plant produced methyl isocyanate, or MIC, an ingredient in the insecticides. And this was the time of the Green Revolution in agricultural productivity. And it turned out that the pesticides produced at the Bhopal plant were less successful than others. And in the early 1980s, the profitability of the plant was declining, and UCC headquarters in Connecticut in the US was actually considering dismantling the plant and moving it to Indonesia. So the plant was going downhill. Maintenance was spotty. There were several small accidents involving MIC in the months preceding the night of December 2nd, 1984, when an explosion released a deadly cloud of MIC that killed over 2,000 people immediately, and eventually many times that number, and injured many thousands. It was the most lethal industrial disaster ever and the focus of horrified attention throughout much of the world. Now, I can't hope to summarize the contents of this small library that's been written about that incident, its causes and its aftermath. What I want to do today is just provide a skeletal account of the course of litigation about the Bhopal disaster and examine briefly the encounter of the Indian legal system with several more recent instances of the negligent infliction of fatal injury. In the days following the Bhopal explosion, amid the confusion, a flock of American plaintiffs' lawyers arrived in Bhopal to sign up thousands of clients for anticipated lawsuits in the US. And when they returned to the US, thousands of suits were filed. The government of India, in the meanwhile, equipped itself with statutory authorization as the exclusive representative of the victims. And the government also decided to pursue the case in the United States. All the Bhopal cases, the government's and those of the private attorneys, were filed in various federal courts in various parts of the US and were consolidated for pretrial proceedings in the Southern District of New York, sitting in New York City. Carbide moved to dismiss the case on grounds of forum non-convenience. That's a rule of jurisdiction, not a constitutional rule. A rule of jurisdiction that empowers a court to reject a case on the grounds it would be more appropriately pursued in a different forum, in a different court. The parties submitted their arguments on this, and I should disclose that I was an expert witness for the government of India on that issue. Alas, the judge, Judge Keenan, was more persuaded by the assurances of Union Carbide's experts, Nani Palkhivala and J.D. Dadachanji, eminent advocates who professed outrage at the notion that the Indian system was incapable of timely and effective resolution of the case, which was the plaintiff's argument. So the government suit on behalf of the victims was dismissed on grounds of forum nonconvenience and sent back to India. Once there, the government of India was reluctant to introduce any procedural reforms or establish a special tribunal because it feared that such innovation might provide a ground for American courts to decline to enforce the Indian judgment. After all, the money was in the US. So if you got a big judgment here, you'd have to take it to the US and sue on the judgment, get an American judgment, and then get paid. So the case in India was assigned to the district court in Bhopal. The only departure from routine was that a judge was assigned to deal with the case exclusively full-time with no other responsibilities. In other words, several years of inconclusive grappling, after which the district court in Bhopal ordered interim relief, a rarity in tort cases, which led to an interlocutory appeal to the High Court of Madhya Pradesh, which upheld it. That is, also gave on a slightly different formula interim relief, leading to a further appeal that put the matter before the Supreme Court of India. At that moment, and we're already in February 1989, 4 years and 2 months after the explosion, the government concluded a settlement with Union Carbide for $435 million, which was immediately endorsed by the Supreme Court. Now the amount, $435 million, was a little higher than UCC had offered earlier, but far short of the $3 billion that the government was claiming. Now it's not clear to me why the government settled for so little. One theory is that it was pushed by an acute shortage of foreign exchange. I think we won't know, perhaps until some of the people involved publish their memoirs, just what was going on. The government of India and many observers, including some in the judiciary, justified that February 1989 settlement as beneficial to the victims by saying, if we'd had further litigation, it would have lasted anywhere from 15 to 25 more years. That was the official statement. This wasn't a claim that the settlement represented the true entitlements of the victims, but it was an assertion that whatever the magnitude of those entitlements, the unchangeable character of the Indian legal system foreclosed the possibility of obtaining those entitlements before the passage of so long a time that the value of those claims was less than the present settlement amount. So the features of the system that ensured protracted delay were treated as given and unchangeable. So far from resolving matters, this 1989 settlement fragmented the controversy and diverted the fragments into several channels. The activists want a retraction of the Supreme Court's initial acceptance as part of the settlement deal, the acceptance of the quashing of the related criminal cases, which eventually were resolved by the conviction of 8 senior Indian employees of the Carbide subsidiary UCIL. They were found guilty of criminal negligence in 2010, some 25 years after the explosion. Prominently absent, of course, was Warren Anderson, the chairman and CEO of Union Carbide at the time of the disaster, who flew to Bhopal in the days immediately after the gas leak, was briefly detained, released, allowed to leave India, never returned, and became the symbol of Union Carbide perfidy to many people. He lived the rest of his life in relative seclusion until his death at the age of 92, just in September of this year. His absence was symbolic of the, quote, escape of Union Carbide and engaged and enraged and unappeased following to this day. Now, in 1999, so we're talking 15 years after the disaster, Carbide equivalent of as many rupees as had already been distributed in those whole 18 years. And in 2004, the Supreme Court of India ordered the government to distribute the remaining funds pro rata to the prior recipients. And there are still disputes about further distribution of funds. You may have noticed that just a few weeks ago, victim organizations dissatisfied with both the compensation and the cleanup were holding a hunger strike in Delhi. Now, these are just the bare bones of the story. To put it in context, let me just mention a few other things. Bhopal occurred 5 years before liberalization and the new openness to foreign investment. It was also just 5 years after the end of the emergency and the recoil against the court's weak response to its excesses. That recoil had stimulated a wave of judicial activism and the birth of public interest litigation, or PIL. Courts were taking the initiative to address various problems. So against this background, the defeatism of the bar and the judiciary's initial response to Bhopal is particularly striking. Apart from the attempt to improvise interim relief, we didn't see any of the innovative energy of PIL in this case. And the reach for a remedy in the US was the reverse side of a deep pessimism about a remedy in India, coupled, of course, with an untroubled and, in the event, unfounded confidence in the US legal system and the anticipation of an enormous recovery. A few weeks after the gas leak, this is back in 1984, the Chief Justice of India observed, "These cases must be pursued in the United States. It is the only hope these unfortunate people have." So at the time, the export of the legal action to the US provoked hardly a murmur of dissent. Later, lawyers attacked the government for its lack of confidence in the Indian legal system eventually eliciting an apology by the government for its insult to the bar and bench. Now, Bhopal provided a vivid reminder of the Indian legal community's lack of interest in tort litigation. Now, there are obviously many brilliant, highly skilled judges and advocates in India, but very little, but taken as a whole, rather little experience or imagination when it comes to torts. To this day, in the Bhopal setting, there's an emphatic focus on criminal liability, that is, on punishment of the bad guys rather than compensation and rehabilitation of the victims and deterrence of future damaging behavior. To an outsider, the virtual absence of any visible investment of reform energy in the legal control of accidents, in spite of a very high accident rate, is striking. And I think not just to outsiders, people here are aware of this. 2 months ago, a bench of the Supreme Court upholding a liability judgment of the National Consumer Commission. This was a judgment involving a 1992 incident about people renting, a municipality renting boats with no life jackets. Which, as you say, it took 22 years. The court requested the Law Commission to propose a comprehensive law of tort liability for government agencies. All of which brings us to the question of why there's so little resort to tort remedies in India. Tort claims in the courts are inhibited by ad valorem court fees, by long delays, by very modest and sometimes difficult to collect awards. Cases arising from car, bus, and truck accidents are in the motor accident tribunals, medical malpractice claims now in the consumer tribunals, but for the great bulk of non-auto injuries, the most prevalent form of relief, if any, is through ex gratia payments. That is payment in which the giver, a tortfeasor, or frequently a governmental body, says, we're giving you this because you were injured, but without any legal obligation on our part. And as you'll see in your daily newspaper, a report of a building collapse or a railway accident or a chemical spill is typically accompanied by an announcement by some government body that it's giving an ex gratia payment of 2 lakhs or 5 lakhs to families of the deceased and something less to those injured. Some of these are one-off, some of them are regularized with terms specified in advance, and you can find long lists of them on government websites. There's sometimes, and we don't know how often, some slippage. We don't know how often, we don't know how much, between the announcement and the actual delivery of the aid. Ex gratia payments are indications of concern and willingness to help, but in many cases at least, I see them as paternalistic, unpredictable, not closely related to need, and involving no ascertainment or admission of fault, and having no discernible connection with prevention. Indeed, they may insulate potential tortfeasors by reducing demands on them. Recovery from the injurers themselves is relatively rare, so legal liability is typically not treated as a factor in prevention. To summarize, the response to Bhopal, if it did anything to link tort compensation with deterrence, prevention, or promotion of public safety, I find it very difficult to discern. Now, a second incident. On Friday the 13th of June 1997, a fire broke out in the Upar Cinema in a prosperous area of New Delhi. Exits in the balcony were blocked and unusable as a result of the installation years before of additional unauthorized seats. 59 theater goers died in the fire, and over 100 were injured. A group of families formed an association and launched a coordinated campaign of litigation against the cinema owners, the electricity board that had housed the defective generator in the basement of the theater, indifferent regulators, and ill-equipped responders. In November 1997, the association filed suit in the Delhi High Court using the writ petition procedure, asking 22 crores compensation and 100 crores of punitive damages to be used, they said, to set up a trauma center in Delhi. In April 2003, that's 6 years later, the High Court in Delhi ordered compensation of 21 crores to the families and 1 crore to the, 21 crores to the deceased, 1 crore to the injured, and assessed most of these damages against the theater owners, the Ansal brothers, and 45% shared by the 3 government units. And in addition, it said, oh, and we'll assess the owners of the theater 2.5 crores because of those unauthorized seats, and use that to establish an accident trauma center. That's the civil case. In the meanwhile, there's a criminal charges that have been brought against the theater owners, the multi-millionaire brothers Sushil and Gopal Bansal, and 14 other people as well. Trial in the Sessions Court commenced 16 months later and lasted 8 years and 7 months. In November 2007, the Sessions Court convicted all of the accused and sentenced the Ansals to 2 years imprisonment. Then the Delhi High Court upheld the brothers' conviction but reduced the sentences to 1 year, and then it went to the Supreme Court. So this past March, 6 years and 4 months after the Sessions Court conviction, and some 16 years after the fire, a 2-judge bench of the Supreme Court upheld the convictions, but divided on the consequences, and I'll come to that in a second. But back to the civil case, which really looked like the great candidate for a breakthrough on the tort liability front. It had everything. It had rich malefactors, sympathetic victims, public-spirited claimants, apparently incontrovertible fault, and no real evidentiary problems. It seemed to open the path to tort relief in disasters. Very much the exception that proves the rule. I mean, it was an event that was big news. The plaintiffs were affluent and well organized, represented by a dedicated lawyer who didn't charge for his services. The defendants included governmental as well as private parties. The wrongdoing included statutory violations as well as common law negligence. The writ petition procedure pressed into service. The case could suffice without a trial because the judges thought there were official reports that covered all the disputed questions of fact. Now, the discretionary attention of higher courts is a scarce resource. Public outrage, astute lawyering, judicial sympathy can capture such attention for an occasional tort case. But as the late Professor S.P. Sate concluded, awards of compensation under the writ jurisdiction can be nothing more than tokenism. Now, it looked as if, in the Upar case, we were going to have an exemplary, shining token. But on October 13th, 2011, 14 years after the fire, a 2-judge bench of the Supreme Court eviscerated the plaintiff's 2003 victory in the High Court. They reduced the damages to a fraction of the High Court's award. For example, they cut the payments to the relatives of deceased victims by 90%, from 2.5 crores to 25 lakhs. The various government agencies that have been found liable were let off, apart from the Electricity Board. So once again, the hope for an exemplary legal response to a mass tort proved unfounded. Now, back to the criminal, to the two-judge bench of the Supreme Court that's hearing the appeal in the criminal case. And kind of interesting that the two judges upheld the convictions but disagreed about the appropriate penalty. One judge would have restored the original 2-year sentence. The other said, no, let's leave it at the reduced 1-year sentence, but also impose an enormous fine of 100 crores, earmarked for a trauma center to be built in the memory of the Bhopal victims. So basically, this judge is saying, yes, this case should have big damages, but as part of a criminal prosecution rather than as recovery in a civil case. In the meanwhile, the brothers remain free on bail pending convening of a 3-judge bench to resolve the question of penalty. As I say, what's really surprised me here was the openness of one of the judges to this fine to be dedicated to a project related basically to giving the demands of the civil case plaintiffs a project of a magnitude far greater than the damages that the other Supreme Court bench, the Supreme Court bench in the tort case, had been willing to countenance. So it stood in striking contrast, it seemed to me, to the reluctance of the bench in the civil case to impose damages at a deterrence-generating level as compared to the willingness to go for the big symbolic penalty in the criminal case. Okay, that's my second example, and now quickly to my third. In 1986, as you know, Parliament passed a Consumer Protection Act that established a nationwide 3-level system of consumer tribunals to provide remedies for deficiencies in the purchase of goods and services. This was held in 1995 to apply to medical services. So suddenly, medical malpractice claimants did not need to invest the court fees and brave the endemic delays of the ordinary courts, and medical claims became a significant part of the caseload of the consumer tribunals. Now, these cases also took a long time, the average of about almost 12 years from filing to final judgment. But what I found particularly striking, looking at a bunch of these cases over a 4-year period, was the small size of the judgments. Putting aside for the moment one case that I'm going to come to shortly, I found 31 judgments that gave figures on amounts, and the median was 3.5 lakhs. The average was a little higher, 5.3 lakhs. So think of the disconnect between the size of the judgments and the time it took to get them. I mean, can you think that a judgment of 5 lakhs, 11 years in the future, is going to generate much of a deterrent signal? Of course, deterrence is generated by the hassle and the reputational effects of litigation as well, not just by the size of the award, but it's hard to believe that these awards are going to send a signal strong enough to induce more careful behavior. Now, less than a year after the Bhopal fire, back in the late 90s, an Indian-American couple were visiting family here in Kolkata. He was a medical doctor, and she was a 36-year-old child psychologist just embarking on her professional career. And she suffered from a rare but treatable skin ailment which flared up while here in Kolkata. She was hospitalized here at the Emory Hospital, where she was treated by several eminent practitioners. The treatment, which included the administration of large doses of an off-label drug, made her worse, and within weeks she was dead. Her husband, Dr. Kunal Saha, complained to the West Bengal Medical Council, which initially exonerated the doctors. He brought criminal charges against them, and he filed a claim with the National Consumer Disputes Resolution Commission against 3 of these doctors for medical negligence, and he asked for 77 crores. In 2006, his case was rejected by the commission. He represented himself, I should say, in all these proceedings, an undertaking costly in many ways. He made, it is said, some 50 round trips between the US and India, went through bankruptcy in the US, failed to get tenure in his academic post in Cincinnati, and so on. So it was not a costless thing for him. But in 2009, he got to the Supreme Court, which reversed the National Consumer Commission and held the doctors liable and remanded the case to the National Consumer Commission to determine the amount of compensation. And in October 2011, the commission awarded him 6 crores plus interest at 6%, which basically doubled the amount. So that's the single consumer medical negligence case that basically involved an amount as much as all the other cases combined. Now, what does it tell us? That the breakthrough here came not in a mass injury case, but in a classic one-on-one claim on behalf of a single high-status plaintiff suing several individual doctors in a hospital. The elevated damages, of course, were based on her expectation of a long career at a high American income. And in that respect, the configuration of Saha is a curious reversal of Bhopal. In Bhopal, we had an American perpetrator and Indian victims. Now we have Indian perpetrators and an Indian American victim. And the Bhopal settlement, which dramatized the low monetary value of Indian lives, but we now have Saha displaying the high monetary equivalent of an Indian life transmuted into an American one. Now, can this ample evaluation of an individual life be transferred back to India? The amount of damages raises tricky questions of valuation in a society of vast inequality. Would expansive tort damages based on monetary loss reinforce inequality? How could damages be arranged to avoid aggravating those existing inequalities? Would it be better to rely on scheduled payments and so on? Many questions if there really was a development of a vigorous tort recovery in India. Let me just say that so far, so long as there's no effective reduction of delay in the presence of enlarged substantive rights and the more substantial damages, all of that, I think, is going to have little effect unless there's unless along with it there's an effective reduction of delay. The tort problem is in large measure a procedure problem. Now, the problem of delay is not a new one. Over the past century, there have been numerous schemes to attack delay. That's a long story in itself. And there is this challenge to develop not only more generous but more timely awards. And is there, I guess the question is there a way to get there from here? Prior experience, including the recent experience when the the Law Ministry and the Supreme Court have announced a grandiose scheme to reduce delay. None of it is very encouraging. But maybe, I'd like to suggest that maybe overall reform is too much to bite off. It's not only difficult to bring about, but frankly, it's not clear what will work. And I think we shouldn't be afraid to admit that we don't have a ready-made solution waiting to be implemented if only people would cooperate. My guess would be that a good substantive tort law is important, but it's only half the battle. If cases take 15 years and produce paltry recoveries, then even the best designed reforms of substantive tort law are unlikely to have much of an effect on safety practices. We need procedural reform, not just new procedural rules, but new practices. And how do we know what will work? And I guess I'd like to close by proposing an experimental approach that's both more modest and more adventurous. Imagine that we could designate a demonstration district, or several of them, like an agricultural program testing new seeds and techniques, with investment in better trained personnel, monitoring of the results of new policies, and taking new policies that might include continuous trials, limited appeals, monitoring the enforcement of judgments, the use of contingency fees or conditional fees, joinder of cases into class actions, monitoring of lawyers to assure that there's no toleration for delay and so forth. You can imagine many different experiments and taking place in many different localities. It seemed to me one aspect of this open experimentation would be to enlist the know-how, the energy, and the imagination of lower court judges who remain an untapped resource in almost all reform schemes. Not to mention the possibility of using law students as clerks and interns to assist the courts in implementing those monitoring programs. That's another possibility. So to sum up, my argument is this. First, the present situation in India is one of too little deterrence of tortious conduct. Second, that enhanced recovery from violators of safety standards could have a useful deterrent effect, as well as providing deserved help for the injured. Third, to produce those deterrent effects, recovery needs to be both more substantial and much faster. Fourth, to make recovery substantial and quick requires thoroughgoing reform of judicial and professional practices. And fifth, exactly what these reforms should be is not presently known. So sixth, a period of experimentation and pilot projects could advance our understanding. I think there's ample talent around to devise such projects, some of it, I'm sure, in this room. And of course, reforms in this area might provide useful lessons for more general reform. So to those of you who are sort of embarking or about to embark on your professional careers, I hope that concern with these questions will end up being part of them. Thank you very much.
Thank you, Professor Galanter, for detailing the experiences of the Bhopal industrial disaster, the Upar fire tragedy, as well as the recent Kunal Saha case. This has left us with much to think about, and I think I speak for everyone in the audience when I say that this has been an intellectually enriching experience, and we're glad to have been here today. I would now request Honorable Justice Altamash Kabir, former Chief Justice of India, to kindly moderate the discussion and give his concluding remarks for today's lecture.
Thank you, Shishda. Thank you very much. You just heard. Am I audible? Can you hear me? Right. just heard a very learned lecture on the consequences of negligence and the related compensation matters and also the criminal liability of those who are responsible for such negligence. All of you who are here this morning are familiar with these three cases which Professor Galanter spoke about. The students who are here, I guess there's a lot that you could have also picked up from this lecture. There are a lot of things to think about what has been said or expressed by Professor Galanter. I'm certain that some of you may have certain queries or certain questions to Professor Galanter for any kind of clarification that you may need. So now we have roughly about 15 minutes for open floor discussion. So may I request you to, if you have any questions which need to be answered, would you raise your hand so that we can understand how many of you are here who would be asking such questions so that we can time it accordingly. Now, is there anybody here who's had, I can't see any hands raised at all. What's happened to the students?
Yes, sir.
Just 1 minute, you're one. Just a minute, you're one. Anybody else? Alright, you'll have a cascading effect, a domino effect. Right. What's your name? Introduce yourself.
Saurabh Bhattacharya, I teach here.
Okay.
Your reference to Professor Sake's remark on the role of compensation in a constitutional tort with litigation, looking for a large-scale reform in our civil justice system.
That we can't rely solely or even mainly on the writ petition. It's just, first of all, it's making a demand on a very scarce resource that is the time of the high courts and the Supreme Court. Secondly, it doesn't have a convenient way to develop an evidentiary record. So I think at best the writ petition can dramatize many of the needs, can perhaps provide some exemplary demonstrations of what courts can do, but basically if you're going to have real use of tort on a scale that can actually improve levels of safety, it's going to have to be done by the district courts. And I think one important thing would be to get rid of, or at least reduce court fees to make access to the district courts for substantial tort cases to give access, but also the access, it seems to me, isn't worth very much unless the cases are able to go through with some expedition. So it seems to me it's a two-pronged thing. One, to reduce the barrier of the court fee, of the ad valorem court fees, and second, to have procedures that will mean an early resolution of the cases.
I guess that answers that question. This is one area in India which has not really taken up, and that is the concept of torts. But this is the only way in which one can possibly think in terms of damages being awarded, which are in sync with the injury concerned to the victims. Sure.
I wanted to ask Professor Galanter if he thinks that in the event of another Bhopal tragedy, God forbid, whether a US district court would consider still using the rule of forum non-convenience to oust an attempt by an Indian party to get damages in the United States, given what has happened in the Bhopal case.
That's an interesting question, one of great personal interest to me, because in, say, 15 years ago, there was a curious case having to do with tortious injury on an Indian ship that was passing, that was going through the Panama Canal from an American port to somewhere else. The victim of the tort, who happened to be a little girl of 5 or 6 years old, was, I have to fill in a little bit. On at least some Indian ships, the officers are permitted to bring their families on board. And this was a little girl whose father was an officer, and she was on board, and another member of the crew lifted her up in such a way to look out the window or something, and she put her hand on a spinning gyroscope, and it was very badly injured. She was put off the ship. She and her mother, they flew to some relatives in New York, and after whatever medical treatment was involved, brought suit against the owner of the ship. And you probably know how you do this, but in case you don't, because it's an admiralty case, you actually have to find the ship. Well, it turned out that this ship called at the port of Philadelphia, not far from New York, sometime later, and the lawyers went down, and what happens is you seize the ship, and then a bond is put up and the ship can go on its way, and you basically sue this bond. So suit was brought, and again, the question came up of forum nonconvenience. The Indian shipping line said, this took place somewhere in the Caribbean, and the ship and all the parties were Indians, and so forth and so on. But this time, actually, the lawyer for this, for the little girl contacted me, and we basically took the Bhopal brief, but this time it wasn't susceptible to the notion that, well, of course this is a huge case and we're going to make sure it goes through quickly. And the Third Circuit in the US said fine, and so the case was kept in the US. The problem was that the case was kept in the US, but the Third Circuit said, but you can only have Indian damages. So it kind of cut both ways, and there was a settlement after that, but not wholly satisfactory, of course, to the injured party. But I think there's at least some suggestion that the American courts, it would be touch and go. I think an argument could be made and might be made. I mean, Judge Keenan was not disposed to keep the Bhopal case there. Another judge might. He was just chosen by lot. The Southern District of New York has about 15 judges, something like that. And which judge gets which case is decided by lot. He was a brand new judge. He had just been appointed to the court. He came in, he had been a United States attorney, that is a prosecutor. His experience was mostly with criminal law. He wasn't a big civil law person. Another judge might well have wanted to keep the case. I mean, so there's a lot of, I wouldn't use the word arbitrariness, but there's a lot of play in whether a case is going to get kept or not. Now, the American courts have been they've been taking like big commercial cases and keeping them and tossing the torts out, and I think there's been some criticism of that. So, there's certainly a good chance. I couldn't assign a number, a percentage to the chance, but there's a real chance that if it happened, God forbid, again, yes, an American court might well take jurisdiction. And then the interesting thing would be what would happen. Would it actually get tried, or would a very small portion of cases that go through the courts in the U.S. end up in trial, although they all sort of move in that direction. But at the moment, the trial rate, say in the federal courts in the United States, is below 2%. That is, of every 100 cases, less than 2 end up reaching trial. They're almost all settled or sometimes dismissed on grounds of that they shouldn't be there. There could be a summary judgment against them. But basically, the number that reach trial and the full-blown presentation of evidence and arguments at trial is very, very small. One question is, would the courts keep it? And then the other question is, well, how would it proceed? Or what would happen to it once it was kept?
Yes, it's good.
I had just 2 additional thoughts with questions attached to them. I think it will be helpful to everybody in the audience as well to assess the issues that you've raised in the lecture. I think 2 important points to be made in this context are, one, that in the Bhopal context, the deep pockets were actually in the United States. Even if we went after all the assets here, it wouldn't have come anywhere close to the amounts required to cover the damages. The second point is the huge difference in legal costs between the United States and India, which would encourage settlement in the United States but not necessarily lead to settlement in India. In part because courts award costs here that are extremely nominal, while in the UK or the US, I believe, costs would be almost actuals. There is the high fees that are paid to lawyers and so on, which of course encourages settlements before the cases proceed. Having said that, I wanted both Professor Galanter as well as Justice Kabir to react to 2 alternative methodologies to deal with cases like this in the Indian context, assuming that we can bring the deep pockets back to India. There is the Onkar Lal Bajaj case, which deals with also not a mass tort, but a mass violation of Article 14, I believe, relating to the petrol pump, what is popularly referred to as the petrol pump scam. Now there, what the Supreme Court did was it appointed 2 judges to go into each allotment to determine if it was legitimate or not legitimate. One was a former Supreme Court judge, one was a former High Court judge from Delhi. And they delivered reports in every case after hearing the parties. And this was in the writ jurisdiction. So, could we potentially have or bring a case like Bhopal to closure quickly by filing a writ petition under Article 32 in the Supreme Court, asking the Supreme Court to appoint commissioners of the stature of these judges, have them present reports to the Supreme Court on liability in the first instance, and then ask the Supreme Court to first adjudicate the liability. And as you know, under our Constitution, Article 141 read with Article 142 permits the Supreme Court to do quick justice. And of course, Article 32 also provides its own remedies. Now, once the question of liability gets adjudicated, then the question would be of damages, which again could be placed before either a lower court or the same commissioners, and they could again present a report to the Supreme Court on which the Supreme Court could adjudicate, allowing everybody a hearing, of course, except that you'd be denied appeals. The company or the corporation would be denied appeals. Now that's one possibility. The second point I wanted to make is, it's not as though we don't have successfully working mechanisms for adjudication on negligence, in the form, for example, of the motor accident claim tribunals. Motor accident claim tribunals. Now, supposing we were to instead file a writ in the Supreme Court, again by way of public interest litigation, and ask the government to consider setting up a specialized tribunal only in order to adjudicate liability as well as damages in a mass disaster case. Now that's a second option for making things more efficient. I just wanted comments from both Professor Galanter as well as Justice Kabir.
First of all, of course, jurisdiction will always be a point. But keeping that aside, if the Indian courts were to take up these cases, then in that case, as you very rightly point out, it's in the writ jurisdiction that things can be done quickly and maybe in a summary fashion. The compensation which was awarded in the Bhopal gas tragedy case was in fact a Supreme Court decision accepting a settlement, and in that settlement, don't forget that it was indicated that all other liabilities would cease. Now, what the American court did, Judge Keenan did, was to throw the ball back into the Indian court. Possibly over the question again of jurisdiction. Now, the example which Professor Galanter gave about this Indian ship, the incident took place in the Caribbean islands, whereas the ship was detained, was crossing the Panama Canal, and it was detained or seized or arrested somewhere on that place. Would the place of arrest determine the question of jurisdiction? Maybe not. Maybe it's a cause of action that would determine the place which would have jurisdiction to try such a case. But again, putting all that aside, in the Bhopal gas tragedy case, I don't know whether you know, but then a judge of the Madhya Pradesh High Court, he was in fact assigned to look into each case, and thereafter he used to go weekly, he used to go over from Jabalpur to Bhopal and then determine the number of cases which he could on one particular day and then award compensation to each case. The problem is that if we were to go through the channels that we have, say before the tribunal or before the lower courts, then in every case you just have to accept the fact that there is a possibility of orders being challenged and questioned at every stage. Now this is for the benefit of the party against whom the claim is made. The more the delay, the more he or the company gains. So if a matter could be really brought up by way of a writ petition under Article 32, read with, as you said, Article 14, Article 141, Article 142, maybe it would have some effect, because although the right of appeal or right of questioning an order of the Supreme Court, even at different stages, may be denied to the people who are alleged to be the perpetrators of the offence. At the same time, things could be smoothened out and the rough patches could be worked out in the Supreme Court itself without having too many interferences. As you know very well, Krishnan, that the Supreme Court of India today is not merely a court, a constitutional court. It takes up all kinds of matters under Article 136. This is the jurisdiction which has opened out, or rather broadened the width of the relief. Now for small matters, while I was there in the Supreme Court, even as to whether interest should be awarded at the rate of 12% or 20%, even that came up to the Supreme Court by way of a petition under Article 136. Now if the Supreme Court were to keep itself occupied with these kind of work, there is always a problem. The other problem that Professor Galanter spoke about, 2 judges deferred. The matter has to go to a third court, a third judge, who would decide the matter. These are all part of procedure and the delays occur there. The court, the Consumer Forum and Dr. Kunal Saha's case is a case in point. This is a case where courts at different stages decided the matter in a different way till it reached the Supreme Court. Thereafter the Supreme Court sent it back to the Consumer Forum, which ultimately awarded this cost. But the cost that was awarded to him, or rather the compensation, how much was it? Did it cover even, say, 10 trips between the USA and India? Maybe not. But the thing is that as far as we are concerned, in India, there's always the concept of assessment of compensation in the Indian context. Sometimes possibly we cannot even think in terms of awarding 50 crores. To us it's a big amount, and our mentality is such that we think that that is a huge amount that is payable. But you take it outside, 50 crores is peanuts. I don't want to make any comments or say anything about what the settlement was as far as the Bhopal case, Bhopal gas tragedy case is concerned. But at that point of time, there were roughly 3,500 people who were victims. And today it has expanded to much more, and I'll say a few words in my closing address. Today the position is much more difficult, but the only thing was collecting that amount and then thereafter distributing it to the people who were affected. Till today, there are 14 areas just alongside the Union Carbide factory which was there. 14 villages, or maybe even a little bit more, have been identified as places which have been permanently damaged as far as the groundwater is concerned. It's one of the most important things in a family's life, water. And I had the occasion to pass various orders in this matter while I was there regarding introducing piped water instead of tube well water from the ground surface, below the ground, to introduce piped water so that that could be sent to each house by way of a separate tap. Now these are various things which we tried to introduce there in the Supreme Court, but the government has its own problems, the state government, finances, everything has to be kept in sight and in Indian conditions to be able to provide proper relief. You should see some of the effects of the effects of the toxic gas which escaped from the Union Carbide factory premises. Methyl, isocyanate. You know what cyanate is? It's like cyanide. You just had to breathe it, and that was enough to choke your lungs. And the effect continued in the bloodstream from generation to the next generation. You have children who are born with such deformities that you cannot imagine. Anyway, that's a different question altogether. We'll come to that maybe later. But today, as far as the suggestions made by Krishnan is concerned, you don't mind me calling you Krishnan, no? He made some very, very useful suggestions. But the one thing is that it may be not very easy to implement. Maybe the ideas are there in our heads. We all want to do something, but maybe certain things do not permit. It's not only money at times, it's also a question of the willingness to be able to do something. It's certain amount of bureaucratic interference, certain amount of policy-making interference. So these are things which we have to keep in mind when we think of the suggestions made by you, which were excellent. These are suggestions which are very good, and if it could be implemented, if they could be implemented, there's nothing like it. It would solve the various problems relating to quick relief to the victims. As you know, Article 21 provides for quick, fair, reasonable trials. But then, as was pointed out, Dr. Kunal Saha's case took 14 years, 16 years. Bhopal gas tragedy, 30 years on, we are still having problems. We have not been able to solve all the issues. So, I would be very glad if a kind of a body could be created, a committee or something which could go into these questions. The Law Commission is there. But apart from that, to put in inputs of people who are in actual day-to-day administration of justice, of the justice delivery system, who could go into these questions further and make their suggestions. And don't forget, after that, there is the legislature, where the matter will have to also be gone into in some kind of detail, and then only finally certain reliefs may be available. I think I can pass it over to...
Well, I just want to add one thought, which is that we get caught up in what we might call the celebrity disaster, the horrible thing that happens that's very visible, highly publicized, and address those, and we can see the problems that we encounter even there. But of course, the great majority of bad things that happen to people are quite low visibility. And it seemed to me we want to set up institutions that not only address what we call the kind of celebrity disaster, but the everyday, totally routine kind of thing where where the electrical wires fall down on somebody and electrocute them, which is not going to get headlines in the newspapers and not going to become a cause where people are marching and so on. But basically, and there's two ways, there's different ways to do that. You could say, gee, if we really had a proficient department of inspections that would go out and inspect all those wires and whatnot at relatively frequent intervals and so forth and so on, we could cut down those incidents and save many lives. And that would be wonderful. The thing is that we shouldn't act as if we have such a facility when it's not there. If it's not there, then as a second best, perhaps, but maybe the best we can hope for, is to have a tort law that's sufficiently threatening so that the people who are putting up these wires are going to pay attention and say, we really better make sure that they're safe, and we better check on them, and we better make sure we're using good materials and skilled workmen and so forth and so on. So I'm certainly not pushing the case that tort is the ideal way to deal with this, but it's one that's actually already there in the law. It's available in that sense. It's not terribly complicated. It doesn't require the creation of a whole new government department and specialists and so forth. It's there, it's available. We have lots of legal talent and imagination that could employ it to address a whole variety of problems. And it seems to me that it's worth, it seemed to me, trying to disentangle tort from the arrangements that are sort of inhibiting it and limiting it in very drastic ways. I just add one other thing, and that is that courts tend rightly to worry about damages being excessive. But on the other hand, if you really want to generate deterrent signals, and you know you're not getting all the cases. In fact, most of the bad incidents that happen never get to court. It's only some that do, and in those cases, it seems to me, the courts should not be fearful about making examples of tortfeasors and that basically penalties or damages have to be high enough to really generate signals that it's not worth doing it this way. It's worth being careful. And that's a very hard lesson. I mean,
not properly satisfied. That's the one.
Vice Chancellor, I'd just like to add one thing to what Professor Galanter has said, especially about the tortious liability. And he did touch upon this fact that, well, have you been on the roads in India? Now, take for instance a city like Kolkata. You have potholes everywhere. And there's no question of trying to even hide such things. What is there in fact, what is real. There are potholes. Now, when your car goes over that pothole, it's suffering all kinds of injury. Has anybody ever tried to move against the municipality to try and get claims for damage to the car? In any other country, not all countries, but in Europe, USA, yes. Any kind of injury to the vehicle would cost the municipality a huge amount of money. But unfortunately, as I said, that concept has not yet fully caught on here. Apart from that, there's also a question of the capacity of the municipality to either repair the roads or to pay the amount given by way of compensation. That's one aspect. Secondly, you talked about celebrity cases. All of us remember with horror the case of the girl who was raped on the 16th of December 2012 in Delhi. She's now called Nirbhaya. The next day, I tell my students that also this is something which they'll be hearing again. On that day, the next day, the headlines was about this girl and a gang rape in a moving vehicle. It really caught the people's eye. And there were candlelight processions, vigils, whatnot. If 2 or 3 pages later, on the 4th page of that newspaper, there was a small little item, hardly about 10 lines or 8 lines, where there was another case of a rape reported of a minor girl. It was right in the inside and nobody noticed it. So, the cause célèbre, the case, well, that had to be tried immediately. We set up special fast-track courts for that purpose. But everybody forgot about the little minor girl who had been raped. The question is, how does the media react? How does the public react? Making a case out of something, forgetting that there are others equally placed and equally in danger. So, these are things which I guess need to be addressed generally, and not only, as you said, on a cause célèbre basis. Professor Gangotri, were you saying something? You put your hand up?
Yes, I wanted to say something.
Have you got a mic? Anybody a hand mic or so? She's the first registrar was here in this university many years ago.
Thank you for the opportunity, sir. I just wanted to add to the experience you were recounting. On 16th of December that day, in Siliguri, a girl was gang raped. She tried to escape and she was burnt alive. She was in the Siliguri Medical College, a non-Bengal medical college. That did not make the media. Sir, behind every instance of this mass disasters and injuries, underlying that, according to me, it's my opinion, factors of perception and a lot of politics. Politics. Nambyar case, as we all know, was at the turning point of a political situation in Delhi, and it got highlighted. There are minor incidents which otherwise would not have got the attention of the nation, is blown up into a huge incident, but equally serious, equally heartbreaking incidences in the rural parts of India do not come to the forefront. And more painful is the fact that the perception of injury and the feeling of having been wronged and the understanding that there is an opportunity of redressal is not there in majority of the rural folks. I think education and awareness at the lowest level, maybe even at the Balwadi, Anganwadi stage, has to be given to the Indian folks so that first they are able to understand and be aware that when are they being injured and there is an opportunity for relief. We are talking of something which is at the upper echelons.
But Professor Chakraborty, as you know, that even this Anganwadi, these systems, they started with the ICPS system. Now they have the ICDS system, which is for the purpose of protecting victims and also for the purpose of providing some kind of relief. Both the systems are there, and this is also being utilized as one of the methods by the legal aid societies, the different units that are there all over the country, for promulgating exactly what you're saying.
So my thesis is, it's being done through people who are not properly trained. They do not even know for what purpose they are there. I am involved in this Abhiyan, and I know the teachers, the helpers, who come there to work. They are not even sensitized on these issues.
The Sarva Shiksha Abhiyan, those teachers?
Yes.
I see. Because I thought that they were trained to...
They are trained to handle children. They are not trained on the nuances of injury, claim, relief, and the awareness and sensitization of the pupil that this is what is called injury and you need to stand up against it. We need to address these issues if we want to bring a social reform. Legal reforms will come by if there's a social movement.
What about our police reforms? A person goes to the police thana in the rural areas complaining that a rape had been committed. What happens at times? It is hushed down. It's hushed down. The other side is called things are hushed down. These are things where we need to look into certain areas.
So call for a movement, call for a social movement. Only then a legal reform is meaningful.
Yes.
You can have umpteen number of reforms on the legal field. It will not have a cascading effect.
But
grassroots movements are something I'm calling for against these kind of situations.
True. Awareness is very important, but possibly today, what we are discussing, the focus of attention is on the manner in which certain negligences by different
I understand. I was refraining, but I couldn't help myself. Thank you for the opportunity.
No, thank you very much. Thank you. Anybody else?
Regarding the title of the presentation, well, I was wondering about the nexus between Bhopal gas case and Kunal Shah case. Apart from the fact that both the cases led into negligence, and one of the aspects of the case is determination of amount of compensation. But however, sir, you know that when we talk about Bhopal gas case, we are talking about absolute liability. Even act of God is not a defense. On the other hand, in Kunal Shah case, we go with reasonable foresight, the basic principle of tort. So, sir, I was wondering the nexus between this Bhopal case.
Do you want Professor Galanter to answer this?
Exactly. Yes, sir.
Professor Galanter?
Yeah. Thank you very much.
I can add later on.
Yes,
we would love to hear from you.
Well, it seems to me that, yes, I mean, these cases are different, different in scale and in their import, but it seems to me that the reason I brought the Saha case in is I think it's an interesting kind of recognition of the value of a life, and I think in that respect it's a kind of it's a breakthrough. It's saying the individual life is tremendously important and worthy of a high level of concern by the society. It's not just something. So I think it establishes a kind of benchmark in terms of the possibility of compensation, but the compensation is really just the reverse of how much care and protection is deserved by each individual. And so as I say, I think it's an important kind of benchmark. Certainly, I thought Upar was going to be that kind of a benchmark, and the court, or at least the one bench, backed away from that. But I think it's terribly, my argument has been that it's important to be able to give this kind of protection on a routine basis to everybody, not only in a few highly publicized cases, but the few highly publicized cases can be very important, it seems to me, in both in mobilizing public sentiment about the importance of this kind of protection, and in setting standards which can then be applied in the less visible cases.
Are you familiar with the expression life link, especially in preventive detention cases? Professor Justice Joymal Bagchi will be more familiar with it, I guess. And that is a life link. The link between Bhopal and Kunal Shah and whatever has happened in between Upahar and other cases, the life link is one that somebody needs to care about what has happened, the worth of a human life, as has been said by Professor Galanter. Apart from that, the link is that negligence on part of people who are in authority or who are in a position to prevent such negligence. One can say act of God, one can say the Bhopal tragedy was not an act of God, but at the same time, the liability has to be fixed in such a way that the negligence ultimately disappears and each are treated, each person, each victim, they are treated, he is or she is treated in exactly the same way. Celebrity cases, like I gave the example of a little child who never got mentioned. Professor Gangoti Chakrabarti spoke about another girl who never got mentioned, but Nirbhaya got mentioned. But what was the outcome of Nirbhaya? The outcome of Nirbhaya was certain knee-jerk reactions in amendments of the the penal code, the criminal procedure code. What happened really? Did it really work? Does it really still work? In the various cases that have happened all over the country since then, people talk about death penalty, people about deterrent, this, that, and the other. But as I said right at the very beginning, people need to sit down together who understand these problems and then decide on the course of action. Is that all right?
Yes.
I think we shall close the... One more?
One more.
Yes, yes, go ahead.
My name is Mahesh, I teach. What I have is something rural and less demanding, working on the individual victim's compensation.
That is precisely what Krishnan said. That is precisely what he said. And I think, yes, the writ methodology could be used for computing deterrent type of compensations.
Not just deterrent, I was thinking even the actual compensation part.
Actual
The
compensation.
huge money being taken up by the High Courts or the Supreme Court.
The
and
huge-
the non-visited, the huge amount of money which maybe the constitutional courts are more comfortable to deal with too.
What do you mean by huge amounts of money that the constitutional courts are taking?
Amounts like, not in that sense, amounts like...
Are you talking about the fees of the lawyers? Then you have to worry about these guys.
No, I'm talking about figures like 3 billion. Maybe before a civil court, that's not a comfortable figure for a civil judge to immediately think about. But 3 billion, including the money for the victims and for restoring the environment or any other kind of damage, that can be adjudicated in a writ proceeding.
Yes, it has been done to some extent in
Yes.
the other proceeding.
I was thinking institutionalizing it and always in a mass tort claim.
That is precisely what we were saying, to try and people who are involved in this kind of activity, who know what is happening, and
lawyers, judges, all people together, if they could put it up. Can I put up anything here?
yes, all putting their heads together to find out some kind of a solution, because it's not an easy thing. It's one can, as a layperson, think of, oh well, this has happened, this should happen immediately. The next day the case should be taken up. All these are, well, good ideas, but wishful thinking at times. Because there's a certain setup, a certain infrastructure through which one must go. At the same time, the expenses which are there in the Supreme Court, like Professor Galanter was saying, hardly cases come to the court in the United States. Experiments started in California many years ago, sometime in the 1980s to the late 1980s, where blocks were put in at every stage when before a litigation came to court. There were people who were appointed for the purpose of assessing what could be the outcome of a particular case, a civil case. And the parties were called, and before the matter could come to the court itself, before it could be filed, there would be several discussions as to what could be the outcome. A person who is suing, this is just a hypothetical figure, a person suing for $300 could at the end of the litigation end up paying $3 million. So these are things which people need to know. There is no point in going on with the case forever. That is how they have cut down on their arrears in court. We have tried to take up this position by way of our legal aid services, Lok Adalat, conciliation. You know about the amendment to the Civil Procedure Code. Section 89 has been added. The first duty of a judge once he sees the plaint is to see whether a workable settlement can be made out. And if it can be, he has to prepare the settlement, give it to the parties. Either the matter could be settled by way of Lok Adalat, mediation, arbitration, conciliation, and even, if necessary, by way of judicial intervention. So all these things have been put in for this particular purpose. But ours is a very, very big country with very, very complex problems, and just look at the population, 1.25 billion. It's not always that simple. Although we may want to have these kinds of remedies, it may not always be available or possible to be made available. Does that answer your question? Not fully. Alright, I think we shall close our this session because we are way beyond time, and we'll have a quick wrap up of what Professor Galanter had to say, what the Vice Chancellor had to say, what our Minister for Law and Health had to say, and what Krishnan Venugopal had to say. But before that, let me just say one thing. Krishnan has already dealt with the person around whom the lecture of today has been concentrated. That's the second lecture, the M.K. Nambyar lecture. In fact, Nambyar, M.K. Nambyar, a legend in his own lifetime, has had connections with this university through his son K.K. Venugopal. K.K. Venugopal has been associated with this particular institution for a very long time. He has been part of the governing council, the executive council, and he has been very, very charitable as far as students are concerned by sponsoring them for moot court competitions abroad. He has been very generous in various things as far as this institution is concerned, and then he also set up the M.K. Nambyar chair. His son Krishnan, whom had many occasions in the Supreme Court to scold, he is another excellent person as far as the council goes and as a human being goes. It's a wonderful opportunity that this college has, this university has rather, to be able to pay tribute to such a person by way of a lecture by no less a person who is known all over the globe, Professor Galanter, Marc S. Galanter, because of his association with problems of how to deal with legal problems and provide some kind of relief as quickly as possible. Professor Galanter has been associated with India, as he himself said, for more than 50 years. Is it 50 years? Roughly about that time. And he has been, like somebody mentioned, I think it was the Vice Chancellor, that he came to India in 1957 as a Fulbright scholar and was part of the Delhi University. He has been a large influence and resource material as far as the Southeast Asian countries are concerned, the legal systems, the legal aid that can be provided. And I think that he's also looking into now at the present moment how to make available legal aid to people who require it and are yet not able to afford it. So you have heard him, you have heard the manner in which he spoke about the various experiences that he himself had, because he himself was a witness in the Bhopal gas tragedy case. There is only one little problem with the Bhopal gas case, and that is, I don't know whether all of you know how it occurred and what was the reason for it to happen. It was not exactly an explosion. When, as Professor Galanter said, that Union Carbide was almost wrapping up its activities here in India and decided to close the Bhopal unit. They were actually trying to sell it. Everything was closed. There was a simple skeleton staff looking after the place. And they were storing something which was needed for the purpose of manufacturing pesticide. Something which, that particular chemical, if it came in contact with water, toxic fumes would be released. This was stored in a particular container which seemed to be foolproof, but unfortunately it didn't. And a certain amount of that chemical came out and it interacted with some of the water which was around the place, and that led to the emission of this very, very vital and dangerous toxic fumes, what is known as MIC. Today, the figures are that about 22,000 or 25,000 people have died, and many people, more than 5.5 lakhs people have been affected by this particular case, by this particular incident. But till today, as has been pointed out by him, the remedy is not fully available. A certain amount was decided, which was, if I remember correctly, 1/10 of what was claimed by the government of India. And ultimately, the settlement was at a certain amount, which I do not wish to go into the details of, but at that point of time there were 3,500 families involved, and the amount was, well, not exactly commensurate with what should have been provided. Even Warren Anderson was allowed to go off, and when God rest his soul, he's died recently. There's no point in going after him any further. But the people with whom the liability lay more or less escaped the entire situation, and an agreement was arrived at which in fact destroyed possibly the very basis of any further claims by the victims. But today, there are certain other repercussions as far as that tragedy is concerned. As I said, even till today, the effects are being felt by pregnant mothers. This particular gas which escaped and went into the body system of a person staying there, close to the unit, it even went into the mother's breast milk, which has caused all kinds of, which is supposed to be the most protective thing a child can have, a baby, an infant can have. But today, that has been the cause of various kinds of problems with children who have been, subsequently they've developed deformities and things of that sort. The suggestions made by Professor Galanter, as far as that is concerned, sort of intermingles with the Upahar case as well. But that was also a case of negligence, and not only negligence, violation of certain municipal rules, where certain additional space was made out for the purpose of putting in some additional extra seats. There were no proper fire extinguishing systems working there, and all in all, it was a kind of a thing which was waiting to happen. It's a tinderbox, it was waiting to happen, and it happened. Then, Dr. Kunal Saha's case, that lady, his wife, died after certain procedures were taken up here in Kolkata. He pursued the case. He is one man who did not give up, and he carried on and on and on till finally he was able to get some kind of compensation from the National Consumer Forum. All these cases, of course, there's one thing which is common, and that is the amount of time it took for the matters to be even settled partially. Other cases still go on, but at the same time, if a person like the value of a dollar at that time and value of a dollar now makes a world of difference. A value of a rupee, say, now we don't even look at a rupee. 10 years ago, 15 years ago, it still had some value. Today, even a beggar, if he comes and asks for alms, if you give him anything less than 5 rupees, he'll throw it at your face. It is happening. It's happened in Delhi. I've seen it happening many times. So one has to keep in mind the value as available at that point of time and what will be ultimately available to the victims after a passage of years. And that is where Krishnan's his some of his solutions that he has suggested, some of his ideas, as well as the others here from the faculty and Professor Galanter becomes very important. Quick relief is the important point in these cases, both by way of damages. Of course, the criminal part can take a little longer. Those are two separate jurisdictions altogether. The criminal courts will take their own view, they will take whatever has to be done, and they will proceed in terms of our laws, which are in fact incorporated in basically in our Indian Penal Code and in other statutes as well. That will take its time, but the immediate compensation that is required for rehabilitation, that it becomes very necessary. I had just told you a little earlier that even till 2013, I demitted office in July. Even till 2 or 3 months earlier, because the summer holidays had intervened, we had to pass orders trying to almost force the Madhya Pradesh government. They committed that we'll put in a pipeline, we'll put in individual taps, we will separate the sewerage and keep it far away from the lines. There is really no way of clearing the ground or the earth up to a certain level from the toxic poisons. I don't know whether you all remember the case of Bichri in Rajasthan. There's also of course that was another case which involved the emission of oleum gas. It's known as the oleum gas case. Then there was this other case in Kerala where a particular area was leased out to a particular multinational firm for the purpose of extraction of groundwater to manufacture certain things. But that area today is almost like desert, in the sense that all around that area the water has been sucked out and a river close by that has also been affected. These are things which we have to take care of, and as Professor Chakraborty said, people have to be aware of these things, and there has to be some kind of a joint effort by people who can bring these things to the notice of the public and also force the government to take certain remedial actions where these things are concerned. The trouble is that we discuss things. We discuss things in seminars. We talk about things which are very, very real, which should be down at the grassroots level. But discussions and seminars ultimately become minutes, and minutes go into the shelves of cupboards and are then more or less forgotten. This is something which you cannot allow. After all this has happened, this is something which must go, or rather must be brought to the notice of the government of the day, in all the states, the central government, so that a concerted effort can be made, as I said, to set up bodies which can go into these questions, make suggestions. The Law Commission can be involved. All these things can be done in a way where some practical good is ultimately done. Professor Galanter has a great deal of experience as far as the legal system is concerned. There is no reason why his expertise, his experience cannot be utilized for these purposes. There are others as well. This is something which we need to sit down and think of and consider. I am very happy that today we have taken up this this topic, because just a couple of days later, the incident in Bhopal, as you know, happened on the night of 2nd and 3rd December 1984. Today, or rather on that date, it will mark the 30th anniversary of the tragedy. But still, there is a long way to go, and there is a lot of things to learn, and the will to do something. I would like to thank the Vice Chancellor for having invited Professor Galanter here. And of course, goes without saying, K.K. Venugopal and his son here, Krishnan, because I know that K.K. Venugopal has, in the past, sponsored various kinds of lectures of this nature, where he has brought people from outside and has borne the costs himself, putting them up here, then meeting their expenses over the journey. He has been always very generous. So I must really thank Mr. Venugopal. Krishnan, please do convey our respects to him and our thanks to him, and especially to Professor Galanter, who I think needed much more time than just this 1 hour. He encapsulated things what he wanted to say, but I think it's great having these kind of lectures, even when you are able to scratch the surface. Thank you so much for your very, very, very brilliant advice. Thank you very much, the audience who has stuck to their seats. And I see the dean of a very unusual law school sitting here. I happened to visit him a week ago. He is from IIT Kharagpur, the Indian Institute of Technology, Kharagpur. The dean, Professor Dr. Vibhuti, he is now in charge of the law school there, which was started 6 years ago. And I understand that they are doing pretty well. Now, I met some of the students there, they were really lovely. In fact, students are lovely all over. And I'm so happy to see one of my favorite students being the compare for today. Shushita has been one of my favorites, and she does a great job. She's done a great job. Thank you very much.
Thank you for the kind words, sir, and for moderating the discussion today. And everyone present here for sharing your thoughts with us. The lecture and discussion wouldn't have been possible today without the presence and support of all the dignitaries present here. And therefore, we would like to present them with a token of gratitude on behalf of the university. I therefore request our Vice Chancellor, sir, to felicitate Honorable Justice Kabir. I also request the Vice Chancellor, sir, to felicitate Mr. Krishnan Venugopal. Thank you for being here, sir. I'd now like to request the Honorable Justice Kabir and Mr. Krishnan Venugopal to kindly felicitate Professor Marc Galanter for being here today. Thank you so much, sir, for being here today and for giving us the opportunity to listen to your words. I would like to now invite on stage Professor Arup Podar for the vote of thanks.
Thank you, Susmati. Now I have the privilege to tender vote of thanks on behalf of the university. First, let me immensely thank Professor Marc Galanter, who traveled from University of Wisconsin, Madison, United States to Kolkata, India, to deliver the second M.K. Nambyar lecture at NUJS. Thank you very much, sir. I profusely thank Honorable Mr. Justice Altamas Kabir, the former Chief Justice of India, for kindly agreeing to preside over this M.K. Nambyar lecture at NUJS, moderating this session and delivering the concluding remarks. Thank you very much, sir. I thank Srimati Chandrima Bhattacharya, Honorable Minister of Law, Judicial Affairs and Health, Government of West Bengal, for kindly agreeing to become the guest of honor for this session. I thank to Mr. Krishnan Venugopal, son of Sri K.K. Venugopal, for his kind presence and representing this M.K. Nambyar Endowment and also providing a brief achievement of Sri M.K. Nambyar. Thank you, sir. I thank Mr. K.K. Venugopal for providing fund for the establishment of this Nambyar Endowment lecture series at NUJS, and also thanks to him for sponsoring the travel and accommodation of Professor Marc Galanter. I thank Honorable Justice Ruma Paul, former Supreme Court Judge, for kindly associating with NUJS and also with this lecture series. I thank Honorable Mr. Justice Jamal Bagchi, the Honorable Judge of Kolkata High Court, for his kind presence. I also thank other judges, Honorable Judges of Kolkata High Court, who are associated with NUJS and also with this lecture series. Let me profusely thank Professor Sujay Basu, the Honorable Treasurer of NUJS, for his kind presence. Let me thank Professor Kushal Vibhuti, Professor of Law and Dean of Rajiv Gandhi School of Intellectual Property Law, for his kind presence. Let me thank Professor Gangotri Chakrabarti, Professor of Law, North Bengal University and former Registrar of NUJS, for her kind presence. Thank you, ma'am. Let me thank Professor I.J. Ahmed, Professor of Law, Calcutta University, for his kind presence here in this occasion. I thank other dignitaries, ladies and gentlemen, for their gracious presence in this second M.K. Nambyar lecture at NUJS. I thank all the honorable members of the General Council, Executive Council, Academic Council and the Finance Committee for extending their excellent support for the organization of this M.K. Nambyar lecture series at NUJS. I especially thank our Honorable Vice Chancellor, Professor Pishwara Bhatt, for untiring support for organizing this M.K. Nambyar lecture series. I thank Registrar, faculty members, researchers, other officers, administrative staff for their full support and presence in this occasion. Finally, my plentiful thanks to students of NUJS. Without the presence of them, this lecture series could not have been a grand success. Thanks for that.
With that, we conclude the second M.K. Nambyar Endowment lecture. I request all of you to please join us for tea and refreshments outside the auditorium. Thank you.